Good morning, one and all. I am Sridevi Jampani, advocate, founder of Egna Legal, together with P. Bhaskar. I welcome you all to the today's webinar, and I welcome Sri M Surender Rao Garu. In fact, we wanted to conduct a series of webinars on service law from since long time. So with the blessings of Surender Rao Garu, today it has happened. We are happy for that. And I request P. Bhaskar Garu to introduce Surender Rao Garu to the audience.
It's a privilege to introduce you to the gathering of webinar. In fact, we are grown up seeing you arguing the service matters in various tribunals. So it's a privilege for us. And Sri Surender Rao Garu is a very senior advocate and is a designated senior counsel from the Telangana High Court. He practiced in Supreme Court, AP and Telangana High Courts. To my knowledge, maybe he's practicing in other high courts and high courts also. Sir, welcome, sir. Today, the topic is an overview of the service law, sir, as we had discussed yesterday. Sir, kindly, sir, you may address the webinar, sir.
Thank you, the organizers of the webinar. Thank you all who are here on the screen today and who are off the screen also today, who has got the access to this program. The topic that is given, today's topic being an overview of the service law. Before I give or I elaborate on the overview of the service law, it may be necessary for me and for you to know what exactly this phrase means. This phrase consists of two words, the first word being service and the second word being law. Service, it is stated, is an activity carried on by a person for another person for a consideration. Therefore, wherever service is rendered or wherever an activity is carried on for another person for consideration, it becomes service. Then, in general parlance, we know the law is one which has been made by government or government agencies or authorities which are empowered to make law. John Austin puts law to be the principles recognized and applied by the state in administration of justice. Therefore, the rules or any order or a legislation made by the state or the sovereign for the administration of justice and which governs relationship between the state and the citizen and relationship between the citizens and citizens, etc., will be called as law. So going by these definitions of service and law, service law is that part of the branch of law which concerns the persons who render service. As you know, service can be rendered or an activity can be carried on for the purpose of an individual person. In such situation, the employment which crops up in such relationship is called as a private employment. In the present day scenario, the employment is mostly available in government sector and also in the sector where we call it as public sector employment, where the government organizations also employ several persons. The third category comes to be in the private sector. Therefore, the employment wherever it is and the employees wherever they are, and the conditions of employment and conditions for the purpose of employees will be termed as service law. Now, the history of the service law insofar as government service is concerned is in two categories. One is called as civil service, another is called as defense service or military service. Civil service is in the normal administration of the civil society. The military service or defense service is relatable to the persons employed in the defense establishments or defense organization of a sovereign country. The civil services in India or civil services for that matter for any country is not today's phenomenon. Even in the earlier days, each country either ruled by kings or by individuals or by democratic process had their own setup where they were required to employ several persons to attend to their official functions. The persons so appointed for the purpose of governing the society or governing the people of the country would become government employees on civil side. Persons who meet the challenges of the opponent or other countries who is engaged in that behalf as a military person, and the service conditions relating to such military persons will become defense service or military service. To go to the history of civil service in India, as put by Madan J. in the celebrated judgment rendered by the Supreme Court in 1985, reported in AR 1985 Supreme Court 1416. He traced the history of the civil services in India to the East India Company. The learned judge, while going back to that era, stated that the East India Company was employing some persons and deputing them to serve in India. Such of those persons employed by East India Company were forming the civil services for the purpose of being employed in India. Similarly, the Crown, British Crown, was also employing some people to serve in India, and they were also called as civil servants for the purpose of India. Thus, the history of civil service in India is traced to East India Company. Thereafter, Government of India Act 1919, Government of India Act 1935 have been enacted. These two acts provided for a civil service in India. Later, by several enactments, the composition of the civil service in India was elaborated. For governing the service conditions of the persons employed in connection with the affairs of the country on civil side were made several enactments or several rules were made even prior to the coming into force of our constitution. Rules were made for governing the service conditions of the employees prior to the advent of our constitution in the form of fundamental rules. Fundamental rules were enacted way back in 19 or were brought into force way back in 1922. The conduct rules were also framed prior to the coming into force of the Constitution. Similarly, several other leave rules governing the employees were also made prior to coming into the force of the Constitution. After coming into force of our Constitution of India, the Government of India and the state governments made either enactments or rules for governing or in respect of service conditions of the employees. There are several kinds of rules governing different conditions of service. I may elaborate them here. Fundamental rules have some fundamental rules will govern general conditions of service, pay of the government servants, leaves or rules regarding leaves, foreign service, etc. The conduct rules govern the civil services. Altogether, all persons in the civil services, they enumerate which of the conducts are acceptable or how a government servant shall behave or how a government servant shall not behave, and what conduct is reprehensible and what conduct is acceptable. The reprehensible conduct or conduct which is not becoming of a government servant is termed as a misconduct. The misconducts were enumerated. Sorry, the conduct rules only stipulate the conducts which are acceptable. The misconducts are enumerated normally in rules called as the classification and appeal rules. Thus, there are certain enumerated misconducts. For example, habitual absenteeism is a misconduct. Misappropriation, embezzlement of funds, insubordination, etc., are the misconducts which have been enumerated under the classification and control rules. Similarly, punishments for misconduct were also enumerated. Punishments like dismissal, capital punishments like dismissal, removal, reduction in rank, compulsory retirement, etc. are called as major punishments. They are enumerated. Similarly, stoppage of promotion, stoppage of increments with or without cumulative effect, censure, etc. are enumerated as minor misconducts. In most of the government sectors, either under central government employment or under the state government employment. Thus, rules were framed not only for governing the conduct of the employees, but also rules elaborate about what conduct amounts to misconduct, and for commission of such misconduct, what punishment can be imposed. Similarly, rules were made for governing other conditions of service. Other conditions of service may be conditions relating to promotion, recruitment, retirement, pension, gratuity, provident fund, etc., etc. Rules were made. So, while speaking about an overview of the service law, I should say that all these matters or all these aspects of the employment of the persons in government service will be taken note of or will be kept in mind by a service lawyer. Then comes in, as you know, most of the service rules made by the central government with small changes were adopted or remade by the state governments. Therefore, the central government employees or the state government employees are governed by altogether similar set of rules. Now coming to the status of the employees in government sector and status of employees in statutory corporations, status of employees in the corporations which are not constituted or established under a statute, and status of the employees in private sector employment may have to be kept in mind. It is stated that a government servant or employment in government and the position of a government servant is one of a status. This was so held by the Honorable Supreme Court in Roshanlal Tandon versus Union of India. It was stated saying that employment under the government is one of status because the employment under the government is governed by statutory provisions either made under an enactment or statutory or a provision made in terms of a statutory rule. Therefore, the government employees are not strictly governed by the conditions of service in the form of a contract. Once they are appointed, maybe that in the beginning or at the time of appointment, it is a contract, an offer of appointment and acceptance of the said offer of appointment, thus making a concluded contract. But once they are appointed, the government employee earns a status and he is not governed by the conditions mentioned in the contract. He is governed by a statutory instrument. Either statutory instrument may be in the form of rules or statutory instrument may be in the form of an enactment. Therefore, a government employee, it is stated, has a status. Now, this far is the, what you call it as, about how a government employee is governed and what his service conditions are, or in what respects the rules are framed, etc. After the advent of the Constitution, you are aware, the Constitution gave certain safeguards and certain rights to a government employee. The government, either central or state government, is given power to enact laws under Article 309 of the Constitution for governing the service conditions of the employees. Proviso under Article 309 of the Constitution of India enables the President of India or the governor of each one of the states to make rules until an enactment is made for governing the service conditions of India. Service conditions of the employees. Therefore, most of the service conditions as we find them are the service conditions made in exercise of the powers conferred by Proviso to Article 309. These rules made under Article 309, as I have elaborated earlier, govern recruitment, govern probation, govern leaves to be taken or how leaves should be taken or organized, etc. Then they speak about ages, minimum age for entering into the service or upper age limit. So the separate sets of rules were framed by either this by the central government and also several state governments governing the recruitment, governing leaves, governing post retirement, that is regarding pension, regarding gratuity, etc. While in service, as I have stated earlier, conduct of government for the purpose of governing the conduct of the government servants, conduct rules were framed. For the purpose of dealing with the misconduct, civil service classification, control and appeal rules were framed. Like that, several conditions of service are governed either by acts or by the rules. Now let us come to what the exact legal position after or in terms of the rules framed under proviso to Article 309 of the Constitution of India, or in terms of the provisions of enactments made under main part of Article 309. As I stated, some conditions of service can be framed under that. But Constitution itself, under Article 311, provides for certain safeguards insofar as it concerns the tenure of the government servant. Main part of Article 311 says that a government servant is not liable to be dismissed, removed, or reduced in rank by an authority subordinate to or lower in rank than the authority by which such government servant has been appointed. Clause 2 of Article 311 says that, or gives a safeguard to the government employee, that he cannot be subjected to these three major, subjected to any punishment, especially major punishments, as I have indicated earlier, like dismissal, removal in rank, or removal from service or reduction in rank, except after an inquiry. It was further stated that for the purpose of conducting an inquiry or for the purpose of imposing punishments after conducting an inquiry, an employee has a right to be put on notice of the allegation against him. And he has also got a safeguard of his replying to the allegations made against him, and also has got a safeguard of being heard in respect of the allegations made against him. Thus, some safeguard is provided under 311. It may be, I may hasten to add that 311 makes a sea of difference between the employment in government and in respect of the employment in other organizations. By 311, the protection that an employee expects for himself is now made a part of a constitutional right. Therefore, that is the right in an employee, not only safeguard, is a right in an employee. The right and safeguard provided in Article 311 puts the government employees on a higher pedestal than the employees working in other organizations. However, I may say that it is only a thin line of difference. The reason being that many of the statutory corporations, many of the corporations which are state within the meaning of Article 12 of the Constitution of India, have borrowed the language of 311 in most of their regulations or instructions which govern the employees. Therefore, in so far as the employees working in or in connection with the affairs of the government, either central or state, or the persons working in government sector undertakings which are either statutory corporations or non-statutory corporations, perhaps now have the same kind of protection, but the protection which the employees of statutory corporations and non-statutory corporations which are state within the meaning of Article 12 is slightly different in the form saying that the protection which a government servant enjoys is a constitutional protection given by the constitution itself, whereas the protection that is given to the employees working in the corporations either is statutory, emanating from the statute by which the corporation itself is constituted, or by a subsidiary regulation or a subordinate regulation made in terms of some enabling provision under the statute by which the corporation has been constituted. So the difference between the employees in government and the statutory corporations is what I have now elaborated. Now coming to the private sector employees. Private sector employees are normally governed by a contract of employment. At the time of employment, the employer gives out the conditions of service or spells out the conditions under which an employee or a person is appointed. An order of appointment may say that the employee on appointment and on assumption of charge would receive a particular amount of salary. He will be given certain number of leaves. His services will come to an end by a particular date, and he will be entitled to some other perks, allowances, etc., or he may not be entitled to perks and allowances, etc. Then what may be that in some cases, even the private employer may provide for same salary, same perks and allowances, same tenure of employment, etc. But if the employer flouts or violates any of the terms of agreement, the remedy which a private employee has got is totally different from the remedy that is enjoyed by the government servants. The government servants, as I stated above, as they have the benefit of a benefit and are safeguarded by a constitutional provision, courts will be readily inclined to give him the necessary relief which he asks for. But in case of employees in private sector, they may have to go to civil courts or the concerned tribunals seeking relief for the violation of conditions of their employment. This is the difference between the persons employed in private sector and the persons employed in government service. Now, this is all what you call it as an overview of the service law in three sectors. Now, I may have to elaborate further in certain aspects of the conditions of service which may become relevant. Now, as I have stated earlier, recruitment is one of the subjects which is there for starting the relationship of employer and employee. While the recruitment in government service is governed by set of rules and a clear procedure. It may not be so when it comes to private employment. It is stated that in view of the mandate of Articles 14 and 16, as every citizen has got a right to be considered for getting employment, government or the authorities in the government will not be free to appoint any person who they choose, but the appointment must be proceeded by a procedure indicated by either a statute or by the rules. For this purpose, normally recruitment is resorted to after giving a notification or an advertisement calling for the applications. By calling for the applications, for calling for the applications and for selecting the candidates and recruiting them, in government sector, a constitutional body called Public Service Commissions have been established or constituted. These public service commissions are normally headed by the persons of high integrity. These the said organization called as public service commissions, or in some cases which may term them as departmental selection committees, give notifications. Now, the notifications, if it is for employment in the government sector, shall be in conformity with the recruitment rules. We call them as recruitment rules or service rules. Service rules may provide for appointment of a person possessing a particular qualification, appointment of a person of a particular age, appointment of a person possessing a particular experience, and appointment of the persons with certain efficiency, etc. All these become part of the notification or advertisement that may normally be given by the public service commissions or by the recruiting agencies, whoever they are. For example, I am told very recently that many of the banking companies or many of the banks on banking sector side are entrusting the recruitment to some recruiting agencies. But even where some recruiting agencies conduct the recruitment, they shall conform to the underlying principles of Articles 14 and 16. The recruitment cannot be at the whims and fancies of the authority who is empowered to make the recruitment, but the recruitment is governed by a set of rules. But it may not be so when it comes to private employment. Private employment, even for a highest post, the employer does not have any set of rules and he may not adhere to any set principle. Therefore, this is the difference when at the stage of recruitment in between the government employment and private employment. I may say that not only this principle applies to government employment, this principle applies to employment in the public services. Public services may encompass services in public sector also. Now, coming to the next aspect, normally a person after appointment is put on a kind of test in the sense that his ability to perform with some kind of attention, devotion and integrity, etc., is resorted to by the employer. If it is in the employment of the government, this is called as putting an employee on probation. Putting an employee on probation is also governed by rules. So it is not the whims and fancies of the employer or the authority to test a government employee in the way he would like to test during this period, initial period, maybe of 2 years, 3 years, or 1 year, as the case may be. This testing is also regulated by the rules or the statute. In the case of private employees, it is at the whims and fancies of the employer. The employer tests the conduct, tests the efficiency, tests the employee in the fashion that he would like to do it. Therefore, this aspect of probation is also governed by a set of rules. Then the next question is about the leaves. After an employee enters the service, an employee may require a time to abstain from the duty on given intervals or on a particular day or particular period. Abstaining from duty for valid reason on intimation to the employer, in general parlance we call it as taking leave. For the purpose of governing this aspect of the matter, in government sector and also in respect of employment in statutory and non-statutory corporations, which are states within the meaning of Article 12, there are certain set of rules or regulations or a code of conduct which we may call them as leave rules. You are aware leave can be or absence can be for different set of reasons. For example, leave which the need for leave arises suddenly and an employee wishes to take leave for 1 or 2 days. Normally such leave we call it as casual leave. This casual leave, this is given a terminology as casual leave. An employee wishes to take leave for some other reason for more number of days. Such leave is normally called as an earned leave. And there are several other kinds of leave. For example, in India, if female employee were to take leave during the course of their pregnancy for the purpose of or at the time of the delivery, then they will be entitled to maternity leave. Then there are, supposing an employee falls sick and he would like to abstain from duty, he can seek the permission of the employer. And in such cases, the leave sought for is called as medical leave. Then there are several other kinds of leave. So the rules framed on with reference to or in respect of this leave are called as leave rules. Similarly, an employee himself may think of serving for a short duration with another organization or with another employee, or the employer himself may think of sparing the services of an employee to another employer or another organization or another department. This we call as deputation. Even for governing this aspect of the matter, there are certain rules. Therefore, if you now examine different aspects of the service like recruitment, probation, leave, then deputation, etc. All these aspects are governed by a set of rules. Now, after entering into the service, an employee may or aspire for moving up the ladder. The employee's desire to move up the ladder, normally we call it as promotion. Governing promotion, there are set of rules. In what conditions an employee will be entitled to promotion, in what conditions he will not be entitled to promotion. So these aspects, of course, fall under service rules or recruitment rules, or even there may be separate rules governing exclusively the promotion aspect itself. So the next aspect of the service called as promotion is also governed by the rules. In private employment, if the employer likes the employee immensely, he may surpass several other senior employees or several other persons who are occupying higher positions and pick up a person in the lowest rung to hold the highest post. But such course is not permissible in government service and in the service of the corporations which are statutory, and even in the corporations which are not statutory. So now we have come to the stage of promotions. Then after the promotions, normally the next step will be a person will be retiring. In Andhra Pradesh, we have got, in Andhra Pradesh and in Telangana, we have got an act called as Age of Superannuation Act. In other places in India, there may not be exactly an act, but rules may govern the superannuation. In government, the Age of Superannuation Act governs. In statutory and non-statutory corporations, there may be rules or regulations governing the age of superannuation. It may be that many of the employees in statutory and non-statutory corporations may retire at the same age as is fixed for the government employees if the employer there fixes the same age. Therefore, the next aspect of the service, namely the retirement, is also governed by a set of rules and the law on the subject, which we call as either an Age of Superannuation Act or etc. Post-retirement, an employee will be entitled to, wherever it is provided by law, for pension. Governing the pension, again there are several rules. One important thing that is to be noted is these pension rules cover several situations. That is, now in the pension rules, the main aspect of it is one has to put in a qualifying service for the purpose of enabling him to get the pension. So there are rules framed stipulating the qualifying service. Supposing an employee in the service rules now prevalent in central government and state government, an employee putting in some 10 years of service will also be entitled to pension. But the rate of pension which an employee putting in 10 years of service, an employee putting in 20 years of service, an employee putting in 30 years, or the maximum service of 33 years differs. So the post-retirement also, the person who was employed in government service is governed by a set of rules. So these rules we call the person or the service, the aspect of post-retirement life of an employee is governed by pension rules. Now, an employee is also entitled to several other kinds of benefits. like gratuity, provident fund, etc. Even for payment of gratuity, the employees other than government servants will be entitled to the benefit of gratuity under Payment of Gratuity Act, whereas gratuity in government service is also governed by the gratuity rules and provident fund rules. So this is all the overall picture of mainly of the government employees. Now let me come to the private employment. As I was trying to say, or as it was stated by many, saying that the private employment differs from the government employment. But as I have stated earlier, even in respect of private employment and employment in government sector, there is only a thin line. Nowadays, private employment is also governed by many statutes. One of the main statutes governing the employment in private sector is the Industrial Disputes Act. The Industrial Disputes Act provides for many safeguards in respect of workmen. Normally, the private employment or persons in private employment are not entitled to enforce the contract of employment. But even in private employment, where that category of employment is governed by any statute like Industrial Disputes Act, Factories Act, or specific statutes like BD and Cigar Workers Act, Journalists Act, etc., etc. They are governed by the provisions of the statute, and their conditions of employment are not purely contractual, but they are toned by the statutes on the subject. In India, there are around 50 labor welfare legislations. These labor welfare legislations, some of them are general in nature, some of them are specific in nature. As I have put it earlier, the BD and Cigar Workers Act. This act is specific to the BD and cigar workers. Similarly, Construction Workers Act, that is specific to construction workers. Employees working in mines are entitled to the benefit or the provisions of a specific enactment, either called as Mines Act or Employees Working in the Mines Act. That there are several enactments made which are specific in respect of a particular category of employment, and there are certain enactments which are applicable to all kinds of employment. As I have stated earlier, Industrial Disputes Act is applicable to altogether all kinds of employment, but where the employee comes under the definition of workman as defined in Section 2S of the Industrial Disputes Act. One may get a doubt whether Industrial Disputes Act applies only to the persons working in industries. The answer can be no, or answer can be yes also. It is true that Industrial Disputes Act applies to the persons working in industries, but the definition of industry as contained in Industrial Disputes Act is very wide. It was so interpreted in Bangalore Water Works case. In Bangalore Water Works case, the Supreme Court holds saying that the question to be put is not what is an industry, but the question to be put is what is not an industry. Therefore, everything where an organized activity is carried on falls within the definition or every organization or every place where an organized activity is carried on falls within the definition of industry. Therefore, persons employed in industry, true that the Industrial Disputes Act applies to persons employed in industry, but as the definition of industry is very, very wide, and as it encompasses every one of the situations, so Industrial Disputes Act covers altogether all kinds of private employment. The benefit given to the workman or a person falling within the definition of workman therein is a statutory recognition of the status of that particular person, though in private employment. Such employees have got certain protections, like Section 25F of the Industrial Disputes Act, Section 25N of the Industrial Disputes Act, give a right to the employee to be given certain benefits at the time of their termination. It also provides for either an information or ratification or approval to be given for the termination of the employees. In the absence of either approval, ratification, or in the absence of giving the benefits to which an employee is entitled to, like some 15 days salary for every completed year of service, etc., the termination of such employee will become void. If the termination becomes void, the concerned forum will be within its powers to order reinstatement. It was so held by the Honorable Supreme Court in 1976 Supreme Court, if I am correct, the case titled as Sundaramani's case. Therefore, even the private employees or the law governing the private employees falls under the definition of service law. Therefore, a service lawyer, in my considered opinion, must be conversant with laws governing private sector employees, with the statute governing that particular corporation, which is a statutory corporation, and the regulations framed for governing the employees for that particular corporation, and also have the idea of several enactments which I have earlier said, around 15 number, which are labor welfare legislations or legislations which are govern or which are for the welfare of the employees. And a service lawyer must also be conversant with several sets of rules governing several aspects of the employment in government when it comes to the service in the government. So this is how an overview of service law as or which I comprehend appears to be. With this, I close my lecture. Thank you. Thank you, everyone who has heard me, who had participated in this webinar.
Here I have a question.
Please.
May I proceed? Yeah, I have a situation. In a departmental appeal, can the appellate authority enhance the punishment awarded by the disciplinary authority under CCA rules? Can he do so?
Can the appellate authority enhance the punishment
awarded by the disciplinary authority under CCA rules? Can he do so?
Yes, there is a provision both under central rules and also the state rules for enhancing the punishment if, in the opinion of the appellate authority, or if it comes to the notice of the appellate authority that the punishment imposed is grossly, what you call it as less than the punishment that should have visited the employee. I'll give you one example. In state civil services classification and control rules, there is a provision saying that a person indulging in embezzlement of funds, misappropriation, etc., shall be imposed with a punishment of dismissal or removal from service. Supposing the disciplinary authority imposes a punishment of stoppage of increments, then appellate authority can say that we have acted contrary to the rules under which you can impose punishment, and I'll substitute the punishment for what you have imposed, a higher punishment for what the disciplinary authority has imposed. Right? Have you followed, sir?
Yes, sir, I followed.
There are specific rules empowering the appellate authorities to impose a higher penalty, sir.
Okay, sir. Just extension to this.
But that power is hedged in with one or two conditions: that it should be exercised within a given period of time. It should be exercised after giving or after putting the employee on notice and giving him opportunity. He cannot do it without following these, what you call it as, conditions. That is, he can exercise the power only within the given period of time which is provided under the rules, and after putting the employee on notice. Is it enough, sir?
Sir, I understand. Sir, on my appeal, sir, it is not by sumo motu. On my appeal, can he do so?
Right, sir. You have brought to his notice saying that you wanted the punishment to be reduced, but he has enhanced the punishment. That is, he has applied his mind to the paper, to the material which you have supplied, and he has come to a conclusion saying that the punishment imposed on you is not commensurate with the misconduct committed by you. Thank you everyone who has participated in this webinar.
Thank you, sir.
With this, we are concluding today's webinar, and I thank you one and all. On behalf of EGNA Legal and on behalf of all the participants, I thank you, Senior Counsel M Surender Rao Garu, for accepting our invitation and sharing his knowledge. And on behalf of EGNA Legal, we announce that we are planning to conduct a series of webinars on each topic of service law. And if you have any suggestions, please text me so that we will take up the session on the specific subject also.